not a stipulation. We'll proceed with the blue jeans and do line item disputes, put you on the stand, and you're welcome to attend. We'll always notice you up, Mr. Grimes. They want to do a blue jeans evidentiary hearing on just the attorney's fees. So I don't think it impacts your client, but if you think of any impact, do let me know.
No, it does not impact my client. It's why I wasn't planning on attending this hearing. So. Okay. But glad you jumped in.
Earlier you said it for an hour, and now you're setting it for 4 hours. Is there a reason why there's an increase in time?
Oh, I just set it for a half day. I can't squeeze you in for like an hour. I'm jammed. But I will see what I can fit you guys in next week. I actually have time.
I'm ready anytime, Judge. I'm ready today, Judge. This dragged this out a long time.
It's not that hard. I mean, you got your bank statements. You've had them since January, kids, and
that's why I said, Your Honor, instead of spending a lot more money on this and potentially getting more attorney's fees for me, it'd be better if we could just go ahead and submit it and have you rule on it, Judge.
Well, I didn't know there would be more attorney's fees for her for defending prosecuting.
You wanted the blue jeans, you get a blue jeans. I'd like to make testimony, credibility, and findings.
Right.
And the best way to confront somebody is in a courtroom setting, whether it's in blue jeans or in a courtroom. So, okay. Did you say you had some type of a proposed solution? Your number? Did you give me that? You didn't give me the final number, did you, Miss Lozano?
It's up there, that $14,000 number. That was a proper number. That 14124. That number. Yeah.
Okay, let me scroll.
But you asked me to bill all the way through today, so you actually asked me to update my bill through to today, so that would be all the motions in between, correct, Judge?
Up through today, and then you have an updated bill for today's proceedings. There it is, $14,124.60. Now, what does Luba think she owes, Mr. Gibbs? Are we close or are we that far off?
I need to talk to her about that, Your Honor. But again, I don't understand the reasoning that someone can look at a bill and say this was an appropriate amount of money for this without seeing the document. And Luba disputes that she got every single thing from Ms. Lozano. She got some things and some things not. But at any rate, I can talk to her, and I will get the written response as quickly as I can about which charges we dispute. I would also note our position for the record is that attorney's fees incurred by Ms. Lozano after she was no longer the attorney in prosecuting her own interests are not something that she can tax Luba for unless she has independent grounds for the rate of attorney's fees for litigating. I mean, it's what she did during the representation pursuant to the agreement. That's our position. If she wants to provide the additional billing, that's fine, but I don't know what her defense of motions would have to do with what my client owed her during the time that she was her attorney.
She'll get to testify, and she can have the right to confront Ms. Lozano about her bill. Now, how long will you get the discovery on the line item disputes to Ms. Lozano so I can set this right away for a 1 hour or 2 hour evidentiary hearing?
Your Honor, he's already done it, so I can't imagine it taking longer than a week for him to get this done.
I didn't know he did those line item disputes, did he?
He's already done it.
I don't know if Ms. Lozano wants to play board games or she wants to get to the truth here. The reality is that, as I said before, I had a few specific things that I gave her in a blanket objection. In order to do what you're asking me to do now, I need to be able to go through it thoroughly, so I'm not bound by that as an interim thing. So I need at least 2 weeks from now. I'm in the middle of a health and appeal, so anytime after 3 weeks.
Okay, so we're looking at the first week of October. Let me see if I can swing something here. Let me see. Any day's not good for you?
In October?
Yeah, or any day of the week. Some are track attorneys and
Oh, I don't have those issues, but I have a number of trials in October already. But
oh, well, how's the first week of October? Is it pretty rough?
I have something on the 9th.
I had some. Well,
the 9th is no good for me. On the rest of the week is fine.
Okay, and I've got, it is like, everything went to virtual conferences, like the specialty court conference and all that, so I've got like 18 conferences lined up. I'm not going to make all of them, but I just want to make sure they won't interfere with my conference schedule, because some conferences are mandatory, some are optional. Okay, so let me see what I have in October. Right, did I offer you, did I put something on October 6th? What is there? That is, that's the Joe Houston and Vince Mayo trial. I'm not sure about that one. Let me find another date. 8th and 9th I cannot do. I have a mandatory conference, so let me see, what would be my next available after
7th?
October?
Can you do the 7th, Judge?
7th? Yeah, let's take a look. I think it's a 2-day trial with Houston and Mayo, and I'm not sure what's going to happen with that one.
Gotcha.
Let's look at the following week. Yeah, I could probably, Joe Houston is one of those lawyers that can't really come into a courtroom and wear a mask for 8 hours straight. So I just don't know if his trial is going to go, but I can't, 13th, 14th,
You already have something scheduled on the 13th on this matter. Supposed to be the hearing, was supposed to be our motions today, so that's already scheduled for Gonzalez, Judge.
Unless you want to go before the senior judge, I'm going to be at the specialty court conference.
Oh no, we need to have you, Judge. You've had a huge history on this. You know this.
Okay.
Sorry.
How about the 12th on a Monday afternoon?
In the afternoon.
I have a trial that afternoon. I'm sorry?
Okay. Yeah, okay, you have a trial that afternoon?
Yes.
For me, the sooner the better. I'm so close to
So, Judge, is that 13th at 9 o'clock vacated then, Judge?
I can't do 13th. That's the senior judge.
No. That was supposed to be for our motions today. So is that vacated? Okay, thank you.
I took everything, get everybody caught up to speed. Yeah, vacated. I wrote that in the top of the chat box.
Okay, thank you.
13 should be vacated. I'd rather do it sooner than later.
Can we do it on the 5th?
Complicated issue.
October 5th?
Is that
The Monday?
October 5th? Let me check my conference calendar.
Okay.
Okay, that one might be. Let me see. October 5th. In the afternoon, let's see what I have. Yeah, that's looking pretty good. Yeah. 1:30 on October 5th.
Thank you, Judge.
For the...
I have... What is that? Oh, I'm sorry, that's vacated. Yeah, I'm available on the 5th. Let me ask Luba if that works for her. Does that work, Luba?
We're doing like this virtually on Blue Jeans. On video.
That's fine. I can do it.
So, evidentiary, I'm going to abbreviate. Evidentiary hearing on fees on Monday, 10/5/2020 at 1:30 p.m. If you guys want to be on time limits, I'll just give you the whole, your whole afternoon, but, it shouldn't take that long. An hour?
An hour each side. I can't imagine it going longer than that.
1 hour each side. Yeah, well, I count it against your directs, your crosses. I'll allocate your time 1 hour each side, and about, 15, no, not even, 10 minutes closing argument, 8 minutes, 2 minutes rebuttal. Attorney Gibbs goes first, in case in chief.
Got it.
Okay.
Who are the witnesses? Just move on to Ms. Lozano, right?
Correct.
And possibly Phil as well.
Okay. So, yeah, so fiancé Phil.
Fiancé.
So do we need a witness list or just do that?
I'm not exactly sure why Phil would be there because it's just court proceedings, and I'm not sure exactly other than...
You're on notice now.
Okay.
Okay.
So that's fine. Mom, Phil, and Miss Lozano. Okay. You go first, Mr. Gibbs. Mr. Grimes, you plan on attending, or you'll continue to give notices, though? All right. Anything else on Miss Lozano's end? Any volunteers to do the order based on my chat box here? So
I don't know how to print that out, Mayor. Is there a print
Print it out and we'll do the order, Judge.
do you have 3 dots at the bottom of the chat box? Do you have 3 dots?
What did I see?
That's it. Yes.
Are you on a laptop?
I'm on an iPad. Is that the reason, maybe?
You know how to take screenshots on your iPad?
No, but Miss Lozano could, as a courtesy, send me a chat with
I was going to
her.
say.
You can just, on it, Nathan, you can just go to the end and download the chat. You can do it on your phone, you can do it on your iPad.
I don't think they have it on iPad. Could Kathy, your assistant, just email it, the chat?
Absolutely. Nathan, you can go to, I just did it. There's a part of the screen that allows you to download it, and it's not in the same place as the laptop. But once you scroll around on your screen, it'll hit it and it'll say download chat.
Okay,
Because I was trying to help someone do it on an iPad.
I couldn't figure it out on an iPad, but okay. You can screenshot it or take a photo.
Make sure you get it, Nathan. No problem. No problem.
You can take your cell phone and take a photo of your iPad, Mr. Gibbs. Okay, so the motion to compel is denied to the extent that she could put up collateral. You don't have to turn over the client file unless you get the collateral. Okay? But once we adjudicate the Blue Jeans evidentiary hearing, a judgment will come forward. Once the judgment is handed down and written in order, okay, we'll see each other virtually, so you'll have to submit it to Department I inbox. Then Ms. Lozano will have her judgment. Then she may turn over the file, or she may charge the plaintiff copying fees if she wants the file, I presume. That's how it works.
I understand. I've done it before, Judge, and once the retaining lien is satisfied, she can get it, not a problem.
Got it. Okay. Yes, Helen, I vacated the 1013 hearing. Thank you for that.
Thank you, Judge.
Is your motion to compel, Mr. Gibbs? Are you going to prepare?
Did you want it separate?
Your Honor, I said you didn't have that.
I'll take it for bonus. Attorney Lozano shall prepare.
I'm sure by next time we'll be able to download the chat, but it's like I said, Nathan, there's just a way that you can move it around the iPad, and it pops up and it says download chat.
Now that we're set for October 5th, any final discovery should be turned in by when? 2 weeks from now, or what?
There's no discovery, Judge. It's just he's going to be doing his line items, and then as soon as I get it back, I need that date. When am I going to get that, and when can I respond, Judge?
I think Nathan asked for 3 weeks.
3 weeks?
But I don't know if the
Do we even have 3 weeks before the 5th?
We won't have 3 weeks before then, so if we can do it in 2 weeks, I'll respond right away.
Well, that's fine, but I would say, in looking at this, if we have some discovery to produce, I don't want to be precluded from doing that. I can get this response about line items, but if there's a document that we want to introduce, can we do that within 2 weeks as well, Your Honor?
Okay, look on the chat box. You'll serve Attorney Lozano any final discovery for trial. Okay? We're more
All the line items by that day, right, Judge?
Yeah, there's exhibit.
I see it.
Exhibit 1, the billing statements. Exhibit 2, the retainer agreement. Okay? That's pretty much it.
Got it.
And once you get the judgment, then she can ask you, can I have a copy of my file now? And then she'll have to pay for copying fees, I suppose. But that's about
retaining lien is settled after we're done with this.
Motion for 60B is granted to the extent that we will amend to have the court acknowledge the state bar fee dispute policy language. Okay, and so I'm striking out what I said because I don't memorize rules and regulations of the State Bar fee dispute at the February hearing. So, trying to see what I'm saying? I don't want to misspeak as to the fee dispute policy, and I'm not bound by it. The policy is if there's an active motion complaint before the district court, they won't move or act on it. They will defer, find out what the Judge Moss does, adjudicates it, and then they're not going to take the jurisdiction of it. So, Argentina
for that as well, right?
Right. Argentina's jurisdiction's been solved. We're just going to get a final dollar amount. They are entitled to a judgment on outstanding fees judgment. It's just a question of how much.
Got it, Judge.
Now, stay on, Mr. Griggs, with Mr. Grimes. Let's get you your trial dates. We don't have to do 4. Do you prefer half days, full days? How many more days you have left?
Your Honor, can I sign out now?
Yes, thank you, Ms. Gonzalez.
Thank you, Your Honor.
Okay, bye-bye. Okay, counsel, what do we have? When will you be ready? I want to make sure dates are assigned, and with the understanding you might be rearranged somewhere in that area, but you can, late December, you might know who your true judge will be. So, preferences.
Well, I think we both think at least another full day. We had written down, as I'm looking, February 2nd, 2021. I assume that's no longer available?
I could check.
Because that's what I thought you said.
Yeah, I thought we had set trial dates in February, so, and I believe that is the correct date.
And if I said it, again, you could be rearranged, but you'll just, the judge can't say no, because if Judge Moss gave it in February, and you'll go sometime in February. You prefer to prepare for a half day or just one full day to start?
Yes.
Your Honor, I would actually rather go a full day and try to get this trial completed.
Yeah.
Kind of difficult, because my 1:30 half-day trials are double stacked all the way through April or May, but I can finagle some morning motion calendar that we can, like on a Wednesday, I can block that out. I found some few dates it might be, coming out of the new year, January, February is pretty booked. But, if you want February date, this gets priority as an unfinished trial, so, what about after, let me see. I already got double stacked. It might have to be half days though if you want February. I'll just lose some motion dates.
You're currently, and I think Nathan raised this, we're currently on my calendar scheduled for a half day starting at 1:30 on February 2nd.
All right.
I already...
I thought it was, I'm sorry, I looked at it wrong. It is half day, excuse me. That's correct.
Yeah, I'm looking at
that was what we could get.
Right.
I want to get this back into court. There's ongoing issues, so I'd like to keep that date if it's available. If it's not, I get it.
Yeah.
Okay.
There's unfortunately, I'm even looking at it now, there's 2 stacked ones there and a stacked 3, so one of those ones is probably a stacked 2. It's triple stacked that day. If you want the morning, you can have it. If you want it, 9 a.m. to 12 noon, the afternoons are on the February 1, February 2. All of this stuff will be rearranged, so if you want 2 half days back to back, February 1, February 2.
Absolutely.
Okay. The 3rd is not available. Okay, let me write that in the chat box.
So I think that's okay for me. Good.
2021, both half days, and they go from 9 a.m. to 12 noon. Stack number 1. JEA to do amended order setting trial. How that works is when we get our 4 or 6 new judges, they're going to have a lot more them. right now. So those calendars, the 6 brand new judges don't exist. When they get away from us, they're going to have a little more breathing room to rearrange. So just dropping a hint, by end of December, you lawyers can call that department that you know you're assigned to and say, hey, we want to make sure we're going because we were one of the unfinished trials, and make sure you kind of push them on that and say, we stay February, do not put us out to June or later. You want to make sure we're going that day. That was a firm date that we were assigned to. So ask if it's firm, they're going to rearrange you or maybe move you to a full day trial. They'll have better breathing room once these new calendars are created. We're choking right now. We don't have any breathing room. But that's guaranteed. You are guaranteed 2.5 days and mornings only for February 1 and February 2. Okay? All right. Is there anything else, counsel? I think that's all we need to resolve to make sure you get assigned dates.
That's right.
No order is necessary as between you two. The JEA will do the amended order and sort it electronically. Okay? All right.
And just to make sure, Your Honor, if I may very quickly, we are in the middle of this trial. Discovery is not reopened, correct?
No.
All right. Thank you.
Now, only to the extent, how is the child school age? Okay, so like school report cards, I usually say they don't exist, but they exist by the time of trial. So if there are new incidents, domestic violence or whatever, if they didn't exist at the time, then it's something that you should let the other side know, at least so then you can argue it in front of the trial judge. No policy, yeah, of course it didn't exist. Now you want to talk about this, and this trial's been pending. Likely new circumstances is probably, and it's relevant. I would probably not prohibit it. I'd probably not. So, all the stuff you had access to in the past, it should have been turned over. I talk about new updated financial disclosure forms, changing a job, you're changing an income, change of residence. Okay, discovery is closed except for updated FDFs, new events that didn't exist. Like a new credit report or something. Recent documents that didn't exist. Etc. I think you can kind of get this there. All right. Very good.
Thank you.
All right. Thank you. So we won't see provisions about discovery or pretrial memos. This is just an amended order giving you the new trial dates.
Okay.
Mr. Grimes, you're welcome to jump in on the hearing on the 5th, but it doesn't have anything to do with you and your client. We are proceeding on the fees dispute on the 5th, but you are officially noticed of it as part of your due process, and you're welcome to attend, and you're welcome not to attend. So this is the fee dispute between Mom and her former attorney. Okay?
Thank you.
Thank you. Bye-bye.